Hello, my name is Rachel Okello and I'm a UK-based solicitor specialising in immigration, nationality and deportation law. And this is day 7 of our 10-day challenge, Coming to the UK for Love, where I've been coming to you every weekday with a different video, different top tips, and also we have a guidebook for you as well, which shows you the steps that you need to take if you want to make an application for a spouse visa to come to the UK, or a residence permit if you're already in the UK to stay here with your spouse or partner who is British or who has indefinite leave to remain or fits into another qualifying category. And I've been speaking to you about qualifying partner. I've been speaking to you about suitability, about genuineness, about the financial requirements, and I spoke to you about exceptional circumstances as well. Today I'm going to talk about the impact of children on an application, because I know many people believe that if a child is involved in an application that it's certainly going to be successful, but that isn't always the case, because what the Home Office rules say, the immigration rules say, and case law, is that a child is a primary consideration, but it is not the only consideration. So the best interests of the child are to be considered at the top of the list, but it's not the only thing that the Home Office or the court need to consider when they are making an application based on spouse visas or based on partnership residence permits if people are already in the United Kingdom. And what does that mean? Well, primarily, one of the things that it does mean is that unless it's considered unreasonable, then the child should not have to stay in the United Kingdom with the family unless you can show that it is unreasonable to expect the child to leave the United Kingdom. And what does that mean? It means that, and it's possibly true, that children can adapt. At the end of the day, they can. You can, if you wanted to, say, oh, we're going to leave England and live in Australia, and we're going to take our children with us because the children will adapt and they will be fine. But there may be a reason why you think, actually, our children won't adapt to us moving to Australia, and you will have reasons specific to your family. And that is exactly the same way that you would need to address an immigration application. So, for example, if the family is already in the United Kingdom, and you have a qualifying partner and you yourself don't have permission to be in the United Kingdom, and you're wanting to make an application to stay with your qualifying partner, and you have a child together with your qualifying partner, then you would need to show why you cannot leave the United Kingdom and make the application from abroad as you are required to do, and why you do not need to meet the immigration rules even if you make the application from abroad. And if you are wanting to use your parental relationship with your child, then you will need to show why your child cannot leave the United Kingdom as well. So why is it unreasonable to expect your child to leave the United Kingdom? And before you say because there's a British parent that the child lives with, because you all live together in the United Kingdom, the Home Office are quite shrewd. And what they will say is, actually, all of you, your qualifying partner and your child, and you can all leave the United Kingdom and live somewhere else in the world together as a family. Because what they say is, whereas you do have a right to a family life, you don't necessarily have a right to choose where you want to live that family life if it means that you're all going to be together. It's only really if you're going to be permanently separated and it's unreasonable for you to be separated that the Home Office can then say, well, okay, we'll grant you leave to remain or we'll grant you entry to be in the UK together. So particularly where there's criminality involved, if the foreign national person has a criminal conviction, then they may say, in fact, you can leave the United Kingdom and leave your child here because you're not a good influence on that child anyway, and your child can stay here with the qualifying partner who is British or who has indefinite leave to remain. So the Home Office are not against, they don't have particular regard to separating families if they think that the immigration rules allow them to separate families. And there are times when you, as a family unit, are going to have to challenge the Home Office because your right to a family life are being breached, and we look for a disproportionate breach. So we say it's not just that your rights are being interfered with, but they're being interfered with and it's disproportionate. It's unnecessary. It's an unnecessary interference with your right to a family life. Okay, so they will then look at whether the child has British citizenship or whether the child has been in the United Kingdom for at least 7 years before that child is even a qualifying child for you to base your application upon. So particularly if it's not a British citizen child and the child hasn't lived in the United Kingdom for 7 years continuously, then that child won't be a qualifying child anyway for you to base your application on. If the child is a British citizen child, or the child has lived in the UK for at least 7 years continuously, then that is a qualifying child, but the application is not going to automatically succeed unless you can show that it would be unreasonable and unduly harsh for that child to either leave the United Kingdom and have to live in another country, or for the child to be separated from one parent or the other. Okay? That's what you're going to have to show. You're going to have to show unreasonableness. It's not just going to be automatic. When there's deportation law involved, it's much more difficult, even if there is a child, than just having an unreasonableness test. But I'm going to do a whole other video on deportation, so I'm going to address that then in the deportation video. So what I really want to get across to you is, it is not just the case that because there's a child in the application that the application is going to be successful. Even if the child is born in the United Kingdom, but the child is not British, and there's reasons why a child can be born in the United Kingdom and still not be British, and that's not going to be discussed in this video, because I have other videos that I've done on nationality that you can look on YouTube, Facebook, other social media that you can look on and see when a child born in the UK will be British. But it's not always the case that a child who's born in the UK is British. So although you may have a child who is part of your family unit, the first thing you need to know is that child a qualifying child, i.e. is that child British, or has that child been living in the United Kingdom for at least 7 years continuously? Or obviously the child could be outside of the United Kingdom and is legally resident in the country that you want to make the application from. Okay, so that will show that the child is a qualifying child for you to even begin to base your relationship upon. And then you'll be looking at the reasonableness test to see whether it is unreasonable to expect either the child to leave the United Kingdom and live somewhere else, or to expect the child to live in the United Kingdom without one of their parents. So the parent who is the non-British citizen or doesn't have leave to remain or indefinite leave to remain, can that parent leave the United Kingdom and leave their child in the United Kingdom with the other parent? So it goes round and round when you're trying to put a child in the mix of your application, but you do have to have very strong evidence for anything that you're going to say, any claim that you're going to make as regards the best interest of the child. You really need to have strong evidence and independent evidence. You could be looking at evidence from an independent social worker or the local authority social worker. You could be looking at evidence from the school, from the church, from the GP, from friends and family. You need to qualify what you're saying and corroborate and substantiate what you're saying with strong evidence, and preferably independent evidence. Okay, so that's it for today. I hope it's been useful for you, and I've loved spending this time with you again as usual. And if you want to discuss your case confidentially and in private with me, because this is just general information, then you certainly can contact us at clarityvisas.co.uk, or you can call us on 01213 894 895, and you and I will have a chat. Okay, thank you, take care, goodbye, see you tomorrow.